This case began with an argument over a bicycle tire and ended in a shooting. Prior convictions and poor choices left Luther Sharp facing 15 years behind bars. The courtroom wasn't just about guilt, it was about accountability and safety.
Okay. Good morning. You're Carlos Rodriguez?
Yes.
And so Mr. Salinas
Yes, right.
has been here before, and we went through some motions, and I granted, I guess, an order for the investigator for Mr. Salinas and the investigator for the Assistant District Attorney's Office to get together at an appropriate time for that investigator to walk through, take pictures if necessary, not touch anything in that home. And
Yes.
is that why we're here today?
Yes, Your Honor. It has not been done as of today. I've sent multiple follow-up emails to Chloe. I understand that new district attorney.
Yes, Ms. French is new on this, so I'm
Yes.
sure she's gotten up to speed. Good morning and welcome.
Good morning, Judge. Thank you.
Yes, Your Honor. But I mean, I've made all good faith efforts. I've put the state in contact with my investigator. I've made diligent follow-ups throughout the last month. And it seems that the order has not been carried out.
And Mr. Gertz, why are you here standing
I
in?
represent Loriana Sola Gomez, Judge, the homeowner of the
Okay,
home whose home is set to be searched, and I'm here to assert his Fourth Amendment rights not to have his home searched without.
well, it's not a search.
I-
I'm not allowing anyone to search anything. It's just a walkthrough to get the kind of the lay of the land of the house is my understanding. So I think there is a distinction with regard to that, and
It
go ahead.
be difficult, Judge, but I mean, the Fourth Amendment, there's no case law that makes such an exception for law enforcement or anybody to just walk through a home and start photographing stuff, and I absolutely object. This person has a Fourth Amendment right to be free from searches, and entering the home is a threshold search issue. And this court has ruled on that in lots of occasions. There's not some imminent threat. There's not some safety sweep. This is a fishing expedition for evidence in a case. And we're asking the government and another parties or a party to a case that my client's not a party to's lawyer's team to be able to enter his home without his permission. And your order specifically says he's got a right to assert his Fourth Amendment rights. I'm here asserting his Fourth Amendment rights.
Your Honor, if I may, the Fourth Amendment protects against unreasonable searches. Given the fact that there might be potential Brady evidence, again, my client is facing potentially up to 40 years in prison. So I think, while of course Mr. Laureano does have Fourth Amendment right, I'm not arguing that he doesn't. That's clearly balanced here, and I'm not the state of Texas, so I wouldn't be able to press charges or on anything that is found there.
Request a search warrant.
Yes.
Your Honor, may the state be heard on this matter? First, let me say that I just, while you've been here, placed my hands on this file. This order came to my attention yesterday when an email was forwarded to me. And so I backtracked a bit to find out how this all occurred. And my initial concern is that the way the order is written, it does seem tantamount to a search warrant. And our CCP 106 says that no person shall be deprived of their right to remain free from seizure of their persons in their houses, their papers and possessions, from unreasonable seizures or searches. Not only was the state not given notice of the motion that was provided to the court in order to have an opportunity to have notice of what was being required or an opportunity to respond in writing.
Well, I think they were. I mean, we were here on this motion previously.
Yeah,
It went.
Kobe argued.
Yeah, there
very
was an
much
argument.
the same arguments that they're both making, both attorneys are making,
So
were made
so
back then.
Everybody stop.
Yes, sir.
Here's what we're gonna do. I'm going to hold the enforcement of the order at this time. I'm going to do some of my own research based on the objections that have now been lodged by the Assistant District Attorney as well as Mr. Gertz on behalf of the homeowner. What I would like is for everyone to do a short brief on the matter and get that to me within a week or so, and then I will make some type of ruling and we can come back and at that point, Mr. Gertz.
Judge, may I make a proposal as sort of an offer and compromise? If the defense would like, I could have my investigator, who's a former Texas Ranger, go and photograph each room in the home. And at the defense expense, it probably costs $300 total or something, but photograph each room in the home and come back and give an affidavit saying these are true and accurate photographs. And we could do it as a business records affidavit, so it'd be admissible at trial. And that way there's no state incursion into my client's home, and there's no other incursion into my client's home. And yet it's a trustworthy source. You know who I'm talking about. And my investigator could come and give us one statement or whatever, proving up the photographs as well.
Your Honor, it seems like we're just, the purpose of that would only be to delay. My initial, my initial motion, Your Honor, was just my investigator at the defense's own expense. I didn't ask for the state's investigator. That was something we compromised on, so.
That's what I ordered so that the homeowner would have
Right.
that level of
Right.
comfort, which is one of the things that Mr. Hopper, but
Right.
why?
Which
so
I don't
hold on.
oppose. Yeah,
Look,
sorry. Your Honor.
if what you're going in for, which I said is not a search and not touching or moving anything, but just to visually inspect layout of the home, then
Yes.
why would there be any issue with allowing Officer Best to go in and take pictures, even potentially a video just of the lay of it, so that there would be, I would ask if he did that, pictures and a video. He could come in, swear, and then that would be the same thing that I was going to allow y'all to do. And that way there's not your people going in. If he's willing to offer that, I think that probably sounds like a good compromise.
We could do it by the end of the week. We can be just done with it.
Well, look, Your Honor, I don't, and I appreciate the counsel's suggestion. My only thing is, because we live in a world full of human beings. I'm not saying that I don't trust whoever their investigator is. It's just I don't see what the issue would be with allowing my
Fourth Amendment.
Sure, Your Honor, sure.
So if we're gonna avoid a Fourth Amendment issue and me getting mandamus or whatever could potentially happen if I force this issue, and there's an easy way around it where I'm potentially not going to get in legal trouble, then I like that idea.
Okay.
And so
And I'm not trying to get you in legal trouble, Judge. Just trying
so what I'm going to do at this time is I'm going to modify the order that I previously entered, and I'm going to take Mr. Gertz up on his, if you're willing, obviously, if you were going to pay your investigator to pay, I'll let y'all get together with the investigator who is a very trustworthy person. He was a former ranger. He comes in and does stuff all the time for different attorneys on both sides of the table here in Jefferson County. So if you guys can get that taken care of, I'll let y'all visit, get that done. I want video, thorough video, so that somebody would know exactly how to potentially lay out a house, pictures of the rooms, every room, and a thorough video of the house. And if you guys are willing to do that, then I will modify the order that is what's going to take place and get that done within, I would say, 2 weeks. Okay.
Your Honor, I would concede to allowing, that ranger, but I would ask for a specific deadline within a week, just given that it's been.
Well, I just said 2 weeks, so we're gonna get it done within 2 weeks. It's already Tuesday.
Can we have it the 24th, just so I have there's like a concrete date? Your Honor.
I'll give you a date.
Thank you.
No, we're on the 10th.
Yes, ma'am.
Let's get it done by Friday, the 20th. Mr. Gertz, Friday, the 20th, that's the rest of this week and then all of next week. If you'll get that done
Yes, sir.
and that information, and And what I would ask is if you would make that available to both Mr. Salinas as well as the Assistant District Attorney.
Yes,
That
ma'am.
way they both have any information so that if he's talking about something, she also has a copy of it. That would be great. All right. I'll make some notes. So what I'm going to do, well, yeah, I'm gonna make some notes. Do you have my signed copy? Give me that one. Yeah, that would be better. So what I'm going to do is make some modifications on that order, date it today, with what that order is that I just did, and I think that avoids all of those issues.
Your Honor, if I may.
Yes, ma'am.
I think it might be prudent to also order that there be no alterations to the home of Mr. Gart's client prior to
As of right now.
this being effective.
Sure. So I would ask Mr. I'll make that a part of the order. And here's the thing, I don't think I can really order them to do anything. They're not a party to this suit. And so I would ask that you please have your client cooperate
Yes.
with not making any changes of substantive. Obviously, they're gonna live in the house, but no major changes before that's taken care of. If they would go along with that, that would be great, but I don't know that I really could order them to do so, but I will make these modifications and then we'll reset it. Probably what I'll do is about a 45-day reset instead of a 30. That gives you the time to get that information back and then to kind of all get on the same page and we'll see where we are at that point.
Thank you, Your Honor.
Okay, thank you. Thank you, Mr. Arch. Thank you, Mr. Salinas.
Thank you.
Good morning. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp was previously in court in cause number 25 DCCR 0916. Entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for a cap of 15 years in prison and a dismissal in cause number 25 DCCR 0917. I've received the pre-sentence report and have you both had an opportunity to review that report?
Yes, Your Honor. I have.
Yeah.
Are there any additions or corrections to the pre-sentence report?
No, Your Honor, I would note for the court, we did receive a follow-up memorandum after the PSI was created. The probation department was able to get in touch with the complainant in this case, and they echoed their agreement with the 15 years.
Okay. I don't see that I have that, but have you had an opportunity to review that?
I don't think I got that.
I would see it on an email.
From probation?
Yes, sir.
Luther Sharp. But it's stating that the family
That the
is.
victim of the
victim
shooting
is-
urged the full 15 years, Your Honor. They don't
Okay.
agree with the deal.
All right, I also have received numerous letters that Mr. Vasquez has provided on behalf of Mr. Sharp. Mr. Nichols, were you given a copy of those?
I was, Your Honor.
And then, in addition, there are jail incident reports. We've talked about those in the past, and I have any updated ones. Have y'all had an opportunity to review that as well?
I have, Your Honor.
Yeah, Sean.
Okay, then, Mr. Vasquez, you may proceed.
Judge, it's just a typo on the first page under defendant's version. First sentence, first line. Then it says I got 2 bikes I got out of Louisiana. I'm sure the court could get that out of the context, but
Okay, they weren't trikes, they were bikes. I mean, there's such a thing. I think
Trikes.
they were trikes.
Excuse me.
I don't know what trikes are.
3-wheel bike.
Well, then I withdraw my
Thank you.
typo correction. I beg your pardon. I should have known Justin doesn't make any mistakes. Judge, I know the court said you have all the support letters. I would just urge the court to sentence Mr. Sharp to something less than the 15-year cap.
Do you have a copy of this? Can you print him one? Give me just a second. I'm reviewing that updated, the memo. I want to make sure I've read that since it has the, interested party victims statement. I'll give you a copy too, Mr. Vasquez.
Thank you.
All right, anything else, Mr. Vasquez?
There you are.
Mr. Nichols?
Your Honor, with his criminal history, urged the court to exercise the full 15 years under the agreement. I mean, that agreement, I think, reflects any consideration and an effort to, I mean, he did admit to it, and that's why, okay, it's lower than it would be otherwise. With his criminal history, he was looking at habitual enhancement. He had not been off of parole, I think, for too very long. Only the last few years. He was last sentence expired in 2018. And by his own admission, he was doing cocaine, caused a disturbance at the house, but he was kicked out. So he shot the home, the resident of the home. I'm asking for the full 15 years.
Thank you, Mr. Nichols. Mr. Sharp, you're lucky you're not here on a murder over a bicycle tire.
Yes, ma'am.
I mean, you went over there with a gun, so it makes me feel like there was some amount of, I don't know if I want to use the word premeditation, but obviously some sense that you were going to cause issues or use that gun to show up just over somebody who was fixing a bike or a bicycle tire. Your last sentence was for 20 years. You received a 30-year sentence back in the 90s. I mean, you've been in and out of prison since probably you were a young man. And the nature of this offense and what now this man has to live with based on the injuries that you caused. I mean, he was, when I say it's lucky it's not murder, it's not like you shot at him. You hit him twice. So to me, your intention was not just to stop him, but to unfortunately, I mean, this is just not the way to deal with an argument over a bicycle tire. Is not to shoot somebody.
He tried to throw me out of his house.
It's his house. He has a right to throw you out of his house. If you go to somebody's house and you start causing issues, it doesn't matter what it is. It doesn't matter if he had your bicycle tire and he wouldn't give it back to you. If that's the case, you leave and you call the police, but you don't go to somebody's house, cause problems, they try to kick you out of their house, and then you shoot them.
Yes, ma'am.
Do you see how crazy that sounds when I say it out loud?
Yes, ma'am.
At this time, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 15 years in the Institutional Division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. And I'm not real sure why a felon in possession of a firearm case wasn't filed against you also, because obviously you are a convicted felon and shouldn't have had a firearm in the first place. But I'm required to read this to you. But so because of the judgment, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Good luck to you, sir. You can go back with the bailiff, and it looks like there's a net second case. I'll find sign that dismissal
Yes, Your
as
Honor.
soon as it comes through.
Thank you.
Thank you.
Thank you. Your Honor.
Raymond Sweet, Mr. Vasquez.
Yes, Your Honor.
I want to give out my address.
Well, that's fine.
After reviewing all evidence, the judge imposed 15 years in prison. Sharp was reminded he is prohibited from possessing firearms or ammunition in the future. This is a sobering reminder. Reckless decisions carry lasting consequences.